The ZBA is a fact-finding body, and to grant variances, it must determine the existence of special conditions, other than solely financial, which create an undue hardship for the applicant. Positive action requires an affirmative vote by at least 4 of the 5 members. ZBA decisions are final, and recourse from ZBA decisions is to a court of law. For items scheduled for a public hearing, residents will have the opportunity to comment on agenda items. In accordance with the Texas Open Meetings Act, members of the board shall not discuss, deliberate, or make any decisions on topics not posted as an agenda item. Speakers should state their name and full address for the record and address all remarks to the board. The board asks that public comment be limited to no more than 3 minutes. And we're going to do our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Salute. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. All right. I will now call for a motion to approve the minutes. Did everybody have you had a chance to look through the minutes?
Yes, I did.
Okay.
So moved.
Okay. Ed
Second.
made a motion, seconded by David. All in favor?
Aye.
Okay. All right, we're going to go into what's called the public hearing items. The agenda is a public hearing to consider a request for an appeal of the city planner's decision as it applies to the approval of a building permit and site plan for the construction of a duplex on Lot 2 of the Johnson's Martinsville Street subdivision, as described in a plat filed April 10th, 2023, and recorded in Clerk's Document 2023-2530 of the Real Property Records of Nacogdoches County, Texas. The property is located on the south side of Martinsville Street, approximately 220 feet from the intersection of Logansport Street and Martinsville Street. This request has been submitted by Philip Blackburn. The case file number is ZBA 2024-05. We will now go into, we'll hear the staff report first, and who will be presenting for the staff?
I will.
Okay.
Good evening, Madam Chair,
Yes.
board members. My name is Nathan Dietrich. I am a third-party consultant for the City of Nacogdoches, and I'll be representing staff in this particular agenda item. So, as previously stated by the chairwoman, is that this is basically an appeal to a decision that was made by the city planner during the building permit process for 720, what is known as 720 Martinsville Road, which is what is to be built there is a duplex, and what they're trying to achieve there. The claim is that the city planner incorrectly applied sections 90-217B, which states that side lot lines. Oh, I'm sorry. Which states side lot lines. And minimum lot sizes are, or about side lot lines, and now how they have to have perpendicular. When a lot line is drawn, it needs to be perpendicular to the road, or there needs to be a notation as to why it's not. And secondly, 90-218, or actually I think it was this, I might have made a mistake here, or this might be an older version, so I apologize. I believe it's 90-217B, which is about minimum lot sizes and how they're related to when a lot size in the subdivision ordinance, it's stated that the minimum lot size shall be 75 feet. Mm-hmm. And this is contesting that we as staff interpreted that incorrectly.
Okay.
So again, here's just an aerial shot of the location of the parcel of land. As the chair stated, that it is on Martinsville Road. Very close to the west is the intersection of Martinsville and Logansport. Part of what we're wanting to talk about is the timeline. Staff also wants to kind of place or make a notation out there is that because this is a subdivision request based on the subdivision ordinance, it is our opinion at this particular time that this body itself, it does not have jurisdiction to respond. However, the reason why we've chosen to go through the process, because I think it's important for some of the new board members to see how we got to this point. And so we all can understand the reasons that the reasons for why we're here today. So in the background of the timeline, back in April 5th of 2023, staff approved this Johnson's Martinsville Street subdivision plat. Okay, and that was done through staff itself. It didn't have to go through Planning and Zoning Commission. On July 13th, 2023, staff received an appeal for the approval of the subdivision plat by Mr. Blackburn. And then on July 27th, 2023, staff responded to that letter to Mr. Blackburn stating the appeal application was more than 90 days, and that time frame to appeal for that particular section of the development process has expired. Then on April 1st, 2024, staff approved a building permit for the construction of this duplex on Lot 2, which is 720 Martinsville Road. And then on May 7th, staff received an appeal letter for the approval of this building permit, again by Mr. Blackburn. And then on June 27th, staff received a third appeal to the interpretation of the building permit for 90-217, as I already stated, that the subdivision did not meet the minimum lot size requirements, nor did it meet the minimum requirements for how a lot should be drawn on the face of the plat, and that the lot lines were not perpendicular to the street. On June 18th, the ZBA heard this agenda item, and it was brought before them on a different notation of the zoning board of 118-427, which talked about how a lot width wasn't correct, and this board. Oh, I'm sorry. That was from before. I apologize. Let me restate that. Is that on July 18th, the ZBA was asked for this item to be placed on the agenda to be heard, and they also agreed to hear it on this particular date, and this brings us to this particular time frame.
Okay.
So I know that's a lot to take in. Is there any questions that I can maybe help anybody out with, or should I just keep on going? Okay.
I do have a question.
Yes,
On,
ma'am.
in the zoning board of adjustments rules, it does say that we hear zoning appeals. But what did I just read in here where there is something to do with the city code that allows this? Or did you just, where would that have been?
No, under 118-100, it states that, which is in the zoning ordinance, it states that there is, if anyone is aggrieved, that they can bring their appeal of the interpretation of the city planner and or the chief building official, and they can bring that to a board. And so that board is you, because it is in chapter 118, which is zoning related items. It also states within your policies and procedures manual that you shall only hear zoning related items, and it also, that information is also backed up within the local government code that you should only hear zoning related items. So it does state within our code. I think this gives us an opportunity to make some changes within our code just to make sure that we are on the straight and narrow on how these things are proposed to you as boards. But I was going to get to that at a later slide.
Okay.
All right, here's a zoning map. And again, why this is important, it's not necessarily for us to discuss today, but just so you know what's going on in the vicinity is that, as you can see, oh, thank you, that this particular lot is zoned R4, which is our multifamily zoning district, and then is surrounded by other R4, and then also R2 and R1. But again, land use is not up for discussion as of today. We are discussing the interpretation of the city planner's interpretation of a building permit, which is citing Chapter 90, which is our subdivision ordinance. I apologize, I did not put this graphically, but I know that all of your handouts has everybody's responses. And I know there was quite a few. There was a lot for, and a lot for, meaning to hear the appeal, and then there was also others to say, I would like for the construction to continue. So I think you've seen all of the ones for and against, and those are all within your packet. There were quite a few that came in after the due date that we place on the application, but we felt it was necessary for you guys to know. And since people are trying to participate, it's important that people do participate, and we wanted you guys to be aware.
Okay, now just for clarification's sake, I've received all those as well, and I wrote down on each lot who was in favor of this and who was against, and I counted 1, 2, 3, 4, 5 people in favor, and 1 person was against.
Okay.
Okay, I just wanted to, is that what you have as well?
Yes. I would say that the tally, I don't have the exact tally. I'm not sure if Amy does.
I have 6. 1, 2, 3, 4, 5, 6. I have 6 letters or emails of people saying they were in favor of.
At that green tab.
There's more to hear the appeal. Yeah, there was quite a few that came in today. And even like right before we came down here,
Okay.
there were a couple more. And again, we at the time of the public hearing, I think you can hear those folks, but at the same time, you know, in the end,
Okay.
I'm not really sure if that's going to be germane to this or not, but again, it's true, is that we should be, everyone should know who has said what.
Okay,
And I can find that out for you after I take a break, if
Okay.
you're hearing the rest of it, and I'll make sure I give you that tally.
okay.
Okay, sorry about that. Okay, so part of when these appeals do come forward, because it is something specified by the applicant, is that and especially in this case, it's a city planner that's being questioned, is that part of the appeal procedures as notated in our policies and procedures manual is that we as staff respond to why we believe that we did the appropriate decision in this matter. So I'm going to address the two items that came up that are being appealed against the city planner, and why we believe that we made the correct decision in moving forward with that particular plat at that particular time. Even though, again, as I said before, is that this is a subdivision ordinance requirement, and the subdivision ordinance, it doesn't, you as a board don't have jurisdiction over it. But again, I think it's important to find out why we're here. So side lot lines under section 90-217B, side lot lines, referring to section 217B, states that side lot lines shall be perpendicular or radial to the street, and the following may be in lieu of bearings. All side lot lines are either perpendicular or radial to street frontage unless otherwise noted. So the applicant claims that the side lot lines are not perpendicular or radial to the street frontage as stated in this section. Therefore, the lot is not valid and requires a variance from the Planning and Zoning Commission. And was called out before a building permit could be issued for the construction of this duplex. And again, just reminding everybody that we're not talking about land use. This is only about this particular line on the plat, or lines on the plat. There are 3 side lot lines on this plat, 2 of which were original from the purchasing property, so on the east and the west sides, which denotes the boundary of the property, right? When that particular owner decided to subdivide the property per city ordinance, they have to come in to do a subdivision plat. So when that subdivision plat came before us, what I believe, and again, I apologize, I wasn't here at the time that the previous planner did this, so I'm kind of ad-libbing for them, but I'm using logic and reasoning as to why I believe that that person did that at that particular time, is that when this came before them, they looked at the plat, knowing that they had to do a perpendicular line, even though it would create a you know, maybe not a conventional or a standard looking piece of property, but in the end, we're following the rules and regulations of the code. This particular recorded plat that you see before you right now is that it does look a little askew along Martinsville Road. That is because if you look in the top left-hand corner, that what you would, in most cases, most of these plats or these maps are done with true north going to the top of the page. This, as you can see, it's a little askew because that's where true north was when this person or surveyor did this particular plat. But if you were to calculate the angle that is at that corner where the only line that could have been drawn on that particular plat, if you look under the top left-hand corner, under A, that angle is 96.17. And we all know that 90 degrees is perpendicular, so it's, I would say it's fairly close, right? And all I can surmise too is that the reason why it was a little askew and wasn't right at 90 was there is, and this again, I'm going from history here, is that there was an existing storage structure or old garage. I think it's still there. You can see it in some of the photos I will show later. And I think they did a little askew just to make sure that they didn't conflict with that particular structure. And again, that's not 100% accurate, I don't know, but all I can assume is that they didn't want to create a nonconformity on that particular lot, on the adjacent lot when doing so. And again, that is not 100% true. I'm just saying that's what I would think if I was reviewing this particular situation. So again, this side lot line was the only city staff, or the only line that city staff had oversight on, due to the fact that the two other, or the lot line or side property line in this case on the east side was already in place because that was the owner's boundary, owner's property line. So that's why that is not, or wasn't able to meet the 90-degree requirement, because they didn't have control over anything further to the east. The requested appeal number 2 was in regards to minimum lot sizes. That, I think there was just a misunderstanding or a misinterpretation of that. Basically, under the subdivision ordinance, it does call out certain widths and length or depths that need to be followed. But how our city works in this particular case is that everything outside in the extraterritorial jurisdiction, which is area that we have interest in as a city, and outside the city limits, reflects these requirements. Everything inside the city limits, you know, anything that's in the city, the zoning ordinance prevails. And so staff just is commenting on this particular one, stated under chapter 118-3, is basically just stating is that we are adopting this particular ordinance, and if there's any conflicts that happen inside the ordinance with these requirements, that the zoning ordinance does prevail. So I just wanted to make sure that we were on the same page for that, and I just want you to know that. You might have some further questions about that, but it was a short description. So again, without, I'm sure there's going to be a lot of questions and comments, so I'll try to get to my recommendation, or staff's recommendation, is that staff recommends to not approve the appeal for the following reasons. And as just previously stated, but I'll restate them, is that the only lot line on the plat did meet the standard, or very closely met the standard when it came to that. I think there's reasonable means to accept certain lot lines that are done if they're not necessarily right at 90 degrees, and there are sometimes a little bit of gray area that is done there. But at that point, what staff does is you go back to the applicability section of the ordinance, right, and says why we're here, why do we have this ordinance in place in the first place, right? And it's for orderly development, which means that people have access to a public right-of-way, and that people have access to health and safety, which usually means, you know, that the ambulance and the fire trucks and things of that nature can get to the property. In this particular case, we see that that is the situation. So I know some people might not agree with that, but in my mind, sometimes you have to be reasonable when you look at these, because not all building and development is black and white. And sometimes you have to be able to look at that and be able to discern what is okay and what is not okay. In this particular case, as you can see on, sorry, this was the proposed building permit that we were looking at. And again, the proposed building permit shows, oh, here, I'm sorry, that's my fault. Shows that in this particular case, even though that it is not a standard conventional lot, this person, the owner of this particular lot, was able to propose a building on there and be able to construct it, meeting all the other property development standards within our codes. Met all setbacks, met all height limitations, coverage areas, minimum lot size, everything that goes along with that. So again, sometimes you go back to how do you apply the code and what makes sense, what's reasonable when it comes down to that. So we already discussed the lot width. The lot width, you know, is the zoning code does supersede or prevail over top of that particular ordinance when that comes into play. Secondly, the proposed structure is being requested for meets all of our setbacks, just as I previously explained. And then lastly, I just want to explain that we as staff have looked into this a little bit further, and we believe that this board does not have jurisdiction to make any sort of appeal when it comes down to this and the way that the appeal was written into you. I know there's others that would disagree, but we also, just to make sure of it, the cities in Texas have I guess it's not a business, but it's a local forum and place where you can reach out to. It's called the Texas Municipal League, and we have I guess we have a subscription, maybe is a good way to say it, to utilize their services and help, because they help all cities and counties in the Texas area. And so we reached out to them and kind of gave them the situation that we're looking at today, and it was their, I mean, there was a long back and forth, but overall, in the end, it was their opinion that this board did not have jurisdiction to do anything when it came down to this appeal. And again, that was an opinion. I mean, everything's an opinion. But we just wanted to let you know is that we take these things very seriously, and we wanted to exhaust all our efforts to ensure that we're giving you the correct information when it comes back from staff. Lastly, this is a little bit out of the purview today, but I just wanted to say this because I'm a bit of an outsider looking in, and I think, you know, I've only been here at the city for a very short time, but I think it's great that we have a lot of people that are excited about it, excited about the city and want to be involved. I think what we found in today's process, we also found that in doing the research and getting prepared for this, we found that there are some holes in our ordinances, and there are some things that we probably should clean up a little bit. And I think it will do everybody a world of good if we were able to do that. Staff has that time to get that done, because then people would be directed and wouldn't be confused by, and no offense, Jerry, by legalese and other wording that sometimes ordinances are written under. And so if we had that opportunity to kind of do those things, and we are bringing forward to the city council and the planning and zoning next week some of those changes that we've already had a joint meeting on. And there are going to be some recommendations from this exercise that we're going to be suggesting to come before those two bodies to make sure that we we better clarify those areas in our ordinance on how appeals are done, who can appeal, when they can appeal, just so there isn't confusion. And then this is really to everybody in the room, is that outside this meeting, I think staff wants everybody to know is that our job as staff is to help both the citizens, the applicants, everybody on both sides of the board. You know, and sometimes it's hard because there are some accusations said that we do things on purpose or not, but we are fallible, we're humans. But our goal is to make sure that this city operates and does things very, very well. So I would like to make sure that people understand that if there are certain processes or things that have been causing confusion or issues, please bring them to our, please bring them up so that we can put them on a list of priorities and how we bring those towards planning and zoning boards like yourself and city council. So if we can fix those issues. And I just want to make sure that people know that the door is open and we're open for any sort of discussion or back and forth when it comes down to those things. That concludes our presentation, and I'd be happy to answer any questions. Oh, and Amy just gave that list to me, Madam Chair, is that it's 1 against, in favor of the appeal is 7.
Okay.
And I'll be over here if you, or does anyone have any questions? If not, I'll.
The re-subdivision of the lot, where it was two lots were created, that was approved by P and Z and City Council, is that right?
It was not.
It was not?
It
So what
was,
process
'cause it
did
was-
they go through?
So there is a process that is acknowledged by the local government code, which is a state, that says that if a parcel has access and is not creating any more utilities or extensive utilities or things of that nature, and it has access on a right-of-way, then it falls into what is, you know, some different jurisdictions call them different names, but amending plats or class 1 plats or whatever that might be. And those types of plats can be actually approved because they either have to, that's where subdivision is very black and white. It's either a yes or a no. And so this one, because it met all of those requirements, it went through just the amending plat process, which means that staff only approved it, and it goes before, then it gets recorded and then does that.
So
There is no further authority on that
So
because,
the administrative plat then?
yes, sir.
Okay,
I'm sorry, I guess
No,
I should have just said
that
that.
makes sense.
So is there an appeal process for an administrative plat?
So that's part of the research that we did. There is a variance process in our current code, but there doesn't seem to be anything that talks about an appeal. However, when discussing it with TML, there is always a way. I mean, there is always a way, really. And what they suggested is that you don't see it very often because usually how this process works is that staff usually says no, and then the applicant who is applying for it wants to appeal staff's decision. In this particular case, the applicant, which is not the owner today, but the previous person, came before they got approved. Now, somebody in the public or, you know, in the vicinity now wants to appeal it. And it's seen that way, right? And I don't think it doesn't define though that process very, very well.
Well, I guess what I'm thinking about, I don't see this, this is just, I'm reading this. This was a new subdivision because he's named it the Johnson's Martinsville Street subdivision. So it was not amending an existing plat.
Yeah, that is my mistake. It's administrative plat. So what they're doing, it is a brand new subdivision. However, in a brand new subdivision, if they have access to utilities and frontage to the road, it still can be considered an administrative subdivision per our ordinance in the way that it's described and defined.
Okay.
Because the key to that, and the reason why behind, yeah, and I'm sorry, thank you, Jerry, is that, and it's also for less lots. So it makes the target very small. But
Okay.
again, what they're trying to do is to achieve efficiency and effectiveness. But again, if it goes through and it doesn't have frontage or it doesn't have utilities, then at that point, staff will be installing those utilities and making sure that it gets there and that the subdivision is created and developed correctly.
Where in the ordinance, Mr. Baker, is where it's 4 or less, it's considered an administrative?
It's in chapter 90.
Chapter 90, I'm not sure of the exact number. I can find that for you.
Okay.
See if I had it here somewhere.
All right, any other questions?
So for a new subdivision, so what you're saying, if there's a new subdivision within the city limits, if it's 4 lots or less, and they can show ingress and egress, they can show utilities, the public would never be made aware of any of that?
That's correct.
Okay.
And also, when you think about those, I mean, you think about how ordinances are written, right? So if it meets the black and white, then there really is no reason why it should come to a board. I mean, it just meets it.
I'm not saying it has to come to a board, it's just the public would never really know
Yes,
unless they,
I'm sorry,
unless they knew to
You
pull
are correct.
plat maps.
you are correct.
Okay.
It's section 90-122,
If you want, found it. It's
subparagraph
Subparagraph
M.
M.
Subparagraph M.
Would you like me to read it?
If you don't mind.
Sure. Administrative plat approval. The approval of minor plats is delegated to the city planner and city engineer. Minor plats are those that involve 4 or fewer lots which front an existing street and do not require the creation of any new street or the extension of municipal facilities. Prepared plat shall contain a certificate of approval by the city planner and city engineer. See Exhibit E attached to ordinance number 889. The city planner and city engineer may, for any reason, elect to present the plat to the Planning and Zoning Commission for approval. The city planner and city engineer shall not disapprove a plat and shall be required to refer any plat which is not approved to the Planning and Zoning Commission. The Planning and Zoning Commission must act on the plat within 30 days after the date the plat is submitted for approval.
Okay.
And if I may, is that I think the author of that code actually had some really good vision. A lot of places where I've worked in the past is that it's just the planner. In this particular case, it's the planner and the engineer. So there's people that are backing the other person's decision up, if that makes sense.
Okay.
Thank you, ma'am.
All right. We'll now hear from the applicant. I believe that would be Mr. Blackburn? Yes. Okay.
Everybody get a copy? I'm Philip Blackburn, 819 Logansport Street. Everybody get a copy of it?
Yes. I have.
In case you want to make notes, this is the PowerPoint presentation. Again, this is 720 Martinsville Street. And this is the plat. And if you zoom in on it, that's it right there. Now, there's been claims by the planning consultant that you don't have jurisdiction to adjudicate this. Newsflash, if you didn't have jurisdiction to adjudicate this, we wouldn't be here. And these are the city ordinances that give you the authority to adjudicate this. This is section 11899. Board of Adjustment shall have the following powers. Subsection 1, decide appeals of city planners' decisions. The Board of Adjustment shall have the power to hear and decide appeals where it is alleged there is error in any order, requirement, decision, or determination made by the city planner. In the enforcement of this chapter, they'd like for that to be a period right there. They're talking about chapter 118. But then it goes on to say, and city rules and regulations. So in other words, anything that the city planner has jurisdiction over and makes decisions about. It goes on to say in section 118-100, appeal of decisions made by city officers, appeal of the city planner's decisions. Appeals to the Board of Adjustment may be taken by any person aggrieved, that's me, or any officer, department, or board of the city affected by any decision of the city planner. not just decisions related to Chapter 118. Such appeals should be taken within a reasonable time, not to exceed 90 days, by filing with the city planner and the Board of Adjustment a notice of appeal, which I did all that, which shall specify the grounds thereof. City planner shall forthwith transmit to the board all the papers constituting the record upon which the action appealed was taken. What happened in this case? They sat on it, and then they tried to cancel this hearing. And that's when I alerted the board of what they were doing, which they didn't have any authority to do. Just imagine, you're appealing the decision of the city planner, and the city planner cancels the hearing. Does that pass the smell test with anyone? The city planner did not have the authority to cancel this hearing. It's nowhere in the ordinances that it gives him the authority. As a matter of fact, as soon as he gets the application, which was duly filed on time, he's supposed to forward that to you guys. It becomes your decision whether you adjudicate it or not. No one else, not even the city attorney. You're a quasi-judicial body. You're independent from the city. Any decision you make can't be overruled by the city council. If anyone has a problem with the decision you make, it can be appealed to court. That's different than suing you. And you can appeal your decision to court, and then the court can listen to it. But the city planner, the city attorney have no authority to cancel the hearing, especially when the appeal was duly filed. So you have the authority to hear this and adjudicate it. It's given to you by the city. And the city ordinance is our law. This authority that was given to you by the city council. So you do have the authority to adjudicate this. Well, we also hear things from the planning consultant that Chapter 90 on subdivisions, that only applies to the extraterritorial jurisdictions out there. That Chapter 118 somehow supersedes Chapter 90. So in the city, it seems like there's really no such thing as Chapter 90. Well, what does Chapter 90 say about that? Here's Section 90-3, the purpose. Purpose of this chapter is to provide for the orderly, safe, and helpful development of the area within the city and within the areas surrounding the city, and to promote the health, safety, and general welfare of the community. The provisions and requirements of this chapter shall apply to all subdivisions within the corporate city limits. That means this one on Martinsville Street, as well as those areas within that area delineated as the extraterritorial jurisdiction. The thing he says that Chapter 90 only applies to, yeah, it applies to that area too, but it also applies to this area within the city limits of the city of Nacogdoches as allowed under the Vernon's Texas Codes Annotated Local Government Code 42.021. So yes, Chapter 90 is in play in the city limits. And you go into Chapter 90 and you look at some of the provisions, and there's a section in there about the lots. And here we are, Section 90, 217B. Side lot lines shall be perpendicular or radial to street frontage, and the following may be in lieu of the bearings. All side lot lines are either perpendicular or radial to street frontage unless otherwise noted. I think we all understand what perpendicular is. That's a right angle to the street. How about radial to the street? Well, that comes from the term radiate. In other words, it diverges as it leaves the street. This is what you expect in a cul-de-sac or in a corner in a subdivision. The lot is narrow at the street, but as you go back, it widens, it radiates. That's how the lots are supposed to be. When we look at this lot, it doesn't do that. And the planning consultant tried to make some argument that this one, see these lot lines on the east and west of this lot were pre-existing, okay? Well, there's no provision in the Chapter 90 about, oh, if you've got pre-existing lot lines, you just, those are exempt. No, there's nothing. The lot lines have to either be perpendicular to the street or radial to the street, or you're going to need a variance. And he made some argument that, oh, well, the one lot line that we drew there was pretty close to perpendicular, is 96 degrees. Well, what's that? The ordinance didn't say lot line. It says lot lines with an S. So the fact that this one lot line here is at close to 90 degrees, 96 he said, that's not really relevant to the code that calls for the lot lines to be either perpendicular or radial to the street. This section here is probably the most important of all. Section 9061 on permits. No permit shall be issued by the Building Inspection Department for any structural lot in a subdivision for which a final plat has not been approved and filed for record. Well, that happened. You can check that box. Permits shall not be issued for any structure unless all required city utilities and streets are in place and operational. Well, they can check that box. Yeah, there's Martinville streets, got water, sewer, electric, gas, all of it. It's the last of it. Nor for any structure on a lot within a subdivision in which the standards contained in this chapter or referred to in this chapter have not been complied with in full. Okay? And that's pretty plain that that's the situation going on here. We have a lot in a subdivision, and it's not complying with some of the ordinances within Chapter 90 on subdivisions, and you can't get a building permit unless you can rectify what's not in compliance or get a variance. Well, let's look at some of the subdivisions around town. These are some pretty recent ones. This is Broadmoor off the Appley Sand Road. And as you look at these lots in Broadmoor, you'll notice that all along these streets where it's a straight street, the lot lines are perpendicular to the street. If you're in a curve, or maybe a cul-de-sac, like down here at the bottom, the lot lines radiate radial to the street. Okay? Well, I thought that the Chapter 90 only applied to the extraterritorial jurisdictions. You'll find this in every subdivision in town. Yes, Chapter 90 applies to subdivisions in this town. It applies to the one on Martinsville Street. This one is of particular interest. It's another recent subdivision. This is Colony Creek. It's out there off when I was in school, that was Hatchet Man Road out there. I don't know if anybody remembers that. It's out there off, I don't know what they call it now, Old Post Oak Road maybe. Back in high school, that was Hatchet Man Road. And as you look at that again, if the street is straight, you have lot lines that are perpendicular to the street, but in these curves, or in this cul-de-sac on the left, you have the lot lines that are radiating, they're radial to the street. But of particular interest is over here on the right-hand side. Call your attention to the right-hand side over here. There's several lots. The 64049, the 64050. Look at those. Those lots do not comply with the subdivision standard. And in a case like this, in this particular case, I think those lots belong to some type of association. They never were intended to build anything on those lots. There's like bushes, grass. It's the entrance to the subdivision. So in our code, it's recognized that you can have lots within a subdivision that do not comply with the subdivision standard, okay? However, there's the safeguard in that code. I'll reiterate that again. This is a safeguard. It's understood you'll have lots within the subdivision that were never intended to be built on. You see that in several subdivisions. But, you know, even though it's owned by a neighborhood association, they can sell it. What comes to mind is that lot there in Buckingham that has a swimming pool in it and tennis courts. That used to belong to the association. But they were well within their rights to sell that. You know, in that Colony Creek subdivision, they might one day decide to sell those lots at the entrance. But the protection and the safeguard in this ordinance 9061 for getting a building permit is that, okay, regardless of how that lot got there in the subdivision that doesn't comply, whether it was on purpose because you were going to plant some bushes there or whatever, or by accident, maybe something there was oversight, they accidentally approved a plat that had a lot in there that didn't comply with the subdivision standards, or even for a nefarious reason, who knows? The safeguard is right here in this section that if you do have a lot that doesn't comply with the subdivision standards, you cannot get a building permit for it until you rectify what is not in compliance or get a variance. Let's look at this lot. This lot, out of the box, required a variance, namely because the side lot lines were not perpendicular to the street, the pre-existing ones. So they failed on that part, in granting the permit for this lot. They got the cart before the horse because this lot needed a variance from the get-go. Okay, then to make matters worse, when I saw this plat, I'd never seen anything like it, where the lot converges to a point, okay? That's not the way you even do it once you get a variance, if you can get a variance. And you have no further place to look than right next door. Right next door to the east of this lot is another subdivision. There's another subdivision right beside this one. This is the Martinsville Road South subdivision. It has 4 lots. 3 along Martinsville Street, the 70297, 70298, 70299, and a lot back behind those, 2794. This was done by James Hurst, okay? Notice those lots, those 3 lots around that face Martinsville Street. Did they try to strike a perpendicular to the line like the planning consultant? Oh, we did our best to make that line perpendicular. That doesn't make any sense to even do that. The 2 lot lines there for those 3 lots, the new ones, were drawn parallel with the existing lot lines. That's sensible, okay? That's the way you're supposed to do it. Here they are, right next to the lot in question. The triangular lots, you've got 70297, 70298, 70299. Those are new lots where the side lot lines are parallel with the pre-existing one, okay? Well, how about around the corner? Another subdivision very nearby, and y'all just worked on this one recently. This is the R.J. Bohack subdivision at the end of Logansport Street. Let's go to the next page and kind of zoom in on it. What the problem with that lot was, the reason why y'all worked on it, where the depth of the lot was only 88 feet. You had to get a variance from you guys. But again, look at what was done. The pre-existing lot lines were on the north end and on the south end. That lot was like 500 foot long. So he platted it into 3 lots. Did they try to strike perpendiculars from the street? No. This required a variance, and guess what? Because this is 4 lots or less and can be done as an administrative plat, these guys are just disregarding the ordinance. They're doing this over, they disregarded the ordinance on the lot on Martinsville Street. They disregarded the ordinance here that when you have side lot lines that are not perpendicular to the street, you need a variance. They could have required that. This went before both the Planning and Zoning Commission and the Zoning Board of Adjustment. He went before the Planning and Zoning Commission to get a down zone. The owner of this property downzoned it from R4 back to R2. At that hearing, he should have gotten a variance for the side lot lines. It's required. But the only variance he was forced to get by the planning department was the one about the lot depth. Okay? So they're disregarding these ordinances on a regular basis. And get this. Notice this plat right here. See this neon yellow box on that plat? What does that say there? It's kind of thought, I blew it up here. Even the surveyor in a neon yellow box alerted the planning department that these lot lines are not up to code. The plat contains side lot lines for lots 1, 2, and 3 that are not perpendicular to the street, which is being noted per section 90-217 of the subdivision ordinance. That's the one we're talking about now. So he's alerting the planning department, hey, there's a problem with this plat. These side lot lines they're not perpendicular to the street. Of course, the standard thing to do is to make them parallel with the existing ones. You might could get a variance for that. And this thing he's talking about down here at the bottom, this configuration still facilitates the purpose of the subdivision chapter, promoting the orderly, safe, and helpful development of the property and health, safety, and general welfare of the community. That's the kind of argument you make at a hearing for a variance. So, we're doing all these things that are required, but we need a variance because the side lot lines are not perpendicular to the street. They disregarded this even though there was a neon yellow sign, okay? What should have been done? Well, number one, they should have filed an application for a variance. And if you do the standard thing for a lot like this, the new side lot line should have looked something like that. Kind of divide the lot into 2 equal halves. But no, they went off at this angle and formed this triangular lot. I've never seen anything like it, and you won't see anything like that in a subdivision. That violates the standards of the subdivision. So what are some of the conclusions we can derive from this? You know, the planning consultant goes into all how convoluted our ordinances are, but there's nothing convoluted about our ordinances other than the planning department's not following them. And I've seen this happen. This happened at the end of Logansport Street. And that went on for 4 years, where they did not follow the ordinances, and it led to disaster. Now, I can believe that in a lot of cases where they're doing these administrative plats, it may never blow up because, like the one at the end of the street, they've left themselves vulnerable to an appeal on that lot. Someone, and it's anybody, anyone aggrieved, can file an appeal on that project because the side lot lines are not perpendicular to the street. The 90 days isn't up. They've left themselves vulnerable to an appeal. I'm not going to appeal. I don't have any problem with the way that subdivision's going at this point. But the point is, they're not following them, and in some cases, when you don't follow our ordinances, it leads to disaster. If you were to follow the ordinances, we wouldn't be having these problems. We wouldn't have had the problem at the end of Logansport Street. We wouldn't be having this problem here. Let's look at some of the things that are out of whack here. They come in and claim you don't have the authority to adjudicate this. Well, there they are. Section 11899, Section 118-100 says you have the authority to adjudicate this. They say, oh, Chapter 90 doesn't even apply in the city limits. It's Chapter 118 supersedes it. That's not how those ordinances work. These ordinances have been in place for decades. Section 90 applies to this subdivision because it's in the city limits, and Chapter 90 applies in the city limits. That's the most important one right there. He talks about there's, someone they really thought this through because they left a safeguard that you cannot get a building permit if the lot does not comply with the subdivision standards. And that's what I did whenever I complained about this thing. I'll address that more later. But I tried to head this off at the pass. I'll say that now, but I'll elaborate on that later. This thing was bad from the get-go, and it needed a variance, and they bypassed that, namely because of this Section 9217B, where the side lot lines are not perpendicular or radial to the street. They should have applied for a variance, and there's a whole chapter in Chapter 90 on getting the variance. Let's go through that. And the body that covers this, the body that has been assigned by our Code of Ordinances to supervise the subdivisions and grant variances for the subdivisions is your cousin. It's not you guys. It's the Planning and Zoning Commission, okay? Planning and Zoning Commission may authorize a variance from this chapter when, in its opinion, undue hardship will result from requiring strict compliance. In granting a variance, the Planning and Zoning Commission shall prescribe only conditions that it deems necessary to or desirable in the public interest. In making the findings required in this section, the Planning and Zoning Commission shall take into account the nature of the proposed use of land involved, existing uses of land in the vicinity, number of persons who will reside or work in the proposed subdivision, and the probable effect of such a variance upon traffic conditions and upon the public health, safety, convenience, and welfare. And see those wording there? That kind of is reminiscent of that neon yellow box. These are the kind of arguments you make at the hearing for the variance. No variance shall be granted unless the Planning and Zoning Commission finds that these conditions, if you look at condition number 3, there's an and. So in other words, all 4 of these conditions must be met. There are special circumstances or conditions affecting the land involved such that the strict application of this chapter would deprive the applicant of the reasonable use of his land. 2, the variance is necessary for the preservation and enjoyment of a substantial property right of the applicant. 3, the granting of the variance will not be detrimental to the public health, safety, or welfare, or injurious to the other property in the area. And the granting of the variance will not have the effect of preventing the orderly subdivision of other land in the area in accordance with this chapter. Such findings of the Planning and Zoning Commission, together with the specific facts upon which such findings are based, shall be incorporated into the official minutes of the Planning and Zoning Commission, meeting at which such variance is granted. Variances may be granted only when in harmony with the general purpose and intent of this chapter, so that the public health, safety, and welfare may be secured and substantial justice done. This is interesting here. Pecuniary, that means financial, monetary, hardship to the subdivider standing alone shall not be deemed to constitute undue hardship. That doesn't have anything to do with it. It's more important about these other items. So I request that the Zoning Board of Adjustment grant my appeal of the city planner's decision to grant a building permit without the said variance. Granting my appeal will require the planning department to follow our ordinances. That's all I'm asking. Also, granting my appeal will require a variance from the Planning and Zoning Commission before a building permit can be granted. The variance will require a public hearing where the neighborhood can have input into this development. Something that was guaranteed by our ordinances, but was denied them by the city planner because the requirement for the variance was disregarded. And you saw the calls that came in that support this appeal. 7. Okay, there's only, if you add up the property, because I know the people on both sides and the backside, all the surrounding property of this lot in question support this appeal, all of them. And the ones behind those. If you add up the property of everyone that is appealing, that supports this appeal of the city planner's decision, it comprises over 80% of the surrounding property. You know, when you draw this 200-foot boundary around the properties, sometimes you clip off just a little piece of someone's property. So, you know, when you say 7 of them, the one that wrote in and sent a letter against granting this appeal doesn't even live in the city limits. He lives out in the county. He's not one of the 200-foot abutters. So I'm talking about the 200-foot abutters. All of those that wrote in supporting this appeal are 200-foot abutters. The one that didn't is not a 200-foot abutters. And out of those, it comprises 85, maybe 90% of the property surrounding this. Those guys have been totally disenfranchised. It's like they don't matter. But they do according to our ordinances. According to our ordinances, when you need a variance like this, you have to have a public hearing, and then everyone that has a dog in the fight, because their property could be, damaged. Something detrimental could happen. They have a dog in the fight. They should be heard. They were ignored. This plat was approved with an administrative plat approval in a back room in the planning department. Nobody even knew about it. I didn't know the thing had been platted until the property had been put on the market for sale. They don't publish their work. And so this is not an appeal about that original plat. It was too late to do anything about it by the time anyone found out about it. But the genius of our code is that for lots that do not comply with the subdivision standards, you have the ability to appeal when they apply for their building permit. And that's the case here. After they applied for and they make a big deal about how long it took, I couldn't do anything about it in 2023. By the time I found out about the lot and the lot of record, it was when they put the property on the market for sale. No one could appeal the original plat. So we had to wait a year for someone to come in and apply for a building. So this is all going according to the ordinances. And so when they came in to apply for the building permit, the ordinances allow you then to appeal the granting of the building permit if you have a lot that does not comply with the subdivision. I think that's all for now. Yes.
Okay. If you'll wait just a minute, Mr. Battler, and we'll see if there's any board members that have any questions.
Okay, sure.
Do you have a question? Do you? Do you have any? Okay. I'll now open this to public hearing. The public will be allowed to comment. We will ask that you limit your comments to 3 minutes, and please, I do know this just, I think from memory, you do need to state your name, and do you need an address Okay, state your name and address, and then please, like I said, limit it to 3 minutes. So do they have to have already pre-registered for that? Okay. If there's anyone that would like to address, if you'll just come to the podium. Yeah, just come on up to the podium and state your name and address. Amy, are you doing a time? Okay. Just a moment, she's going to start the timer. Okay.
Okay, Mario Perica, 708 Martinsville Street. We own the 1930 Craftsman home that's next door to this lot
Okay.
in question. We absolutely love the home. We plan to have this be our retirement home. We're not going anywhere anytime soon. We love the history of this location, and we have great friends and connections in this town. All we ask is the property is safe, well-maintained, and whoever lives there is respectful, follows the law, and doesn't cause trouble. I don't think that's too much for us to ask. This lot in question was already under contract when we bought this home. So we didn't really have any say in what was going on with this lot. This duplex and all this stuff was already in process before we bought this home. But we chose to buy it anyways, knowing all of this. And we could have just walked away from the whole deal and not bought the home and looked elsewhere, but we just loved the home so much and it checked all of our boxes, so we went ahead and bought it. But yeah, absolutely 100%, we wish we would have been able to buy this lot. But it was, like I said, it was already under contract, so there was nothing we can do about it. As far as the two-story duplex is what's proposed, as far as what's supposed to be going on to this lot, we're not super thrilled about it. I don't think anyone really is thrilled to see that on our street, considering that there's no other two-story homes on the street. All the homes are single-story. It's not a huge deal, but you know, we're just not really sure what it's going to do to the character of this neighborhood. But you know, if for whatever reason the property owner decides to sell, we would really appreciate to have the first right of refusal to be able to purchase the lot. And if, you know, that's really all we have to say on this matter.
Okay.
Thank you.
Thank you. Is there anyone else?
Yes, Richard Massey, 909 Cason Street, honorable members of the ZBA. I would like to speak in favor of the appeal process, just to make sure that the residents of the area, which I am, I either walk by or drive by that lot basically every day, and I know that the house that this gentleman is talking about, it's a very beautiful home. It's not a mansion or anything like that, but it's a great place to live. So you chose well when you bought there. You know, just going to the whole character of the neighborhood, but if there are any zoning issues in there that Mr. Blackburn brought up, all of those need to come to light in a full hearing, just to make sure that you guys are making a proper decision about what is a great area in one of the great cities in Texas. So I would like to see the full appeal process move forward. Thank you.
All right, is there anyone else? Okay, we will. I started to say, I was just reading, you have the opportunity for any rebuttal. But it's only if anyone spoke in opposition, or it says against the request. And is there anyone against? Excuse me? Okay, would you like to address the board? Okay, please.
My name is Adam Myatt. I'm the owner of the land in question here. And I just wanted to say, we have done nothing wrong. We purchased the land in 2023. We didn't ask for any zoning changes. I've never been to this board to ask for zoning changes. So when we purchased the land, it was purchased legally. It was zoned multifamily. The plot was already plotted out in the Nacogdoches County Clerk's office. So we've tried to follow all the rules and regulations. We've had several stoppages due to Mr. Blackburn's actions. But I just want to kind of go over the cost of what we have already started in the project. So we purchased the property for $25,000. We've already invested $6,000 in tree removal. City permits, $692. Blueprints, $2,400. Site plan development, which we worked on for over a year, of $2,500. Land survey, $1,200. We've already got the pad built for this, which was $3,800. We've already have the water. We paid the city $1,200 for that. We've also invested already in our flooring of $3,600. Exterior doors have already been purchased for $1,800, and appliances for $4,600. So, as me as an investor, and like I say, we have about $52,000 invested in this. And like I say, we've followed all the rules and all the regulations according to legal rights. I mean, we purchased it. When it was advertised, it was zoned multifamily. So we didn't ask for any variances or any zoning changes when we bought this. However, there is another question, the land on Logan Sport Street, which Mr. Blackburn has been very successful at appealing that one, but that one does not pertain to this land. That land was zoned, I think, single family, and they did request a zoning change to multifamily. So there is some questions there. But like I say, we followed every letter to the process. And unfortunately, this appeals process has severely impacted us financially. We've got a lot of money, so we've projected it to take 6 to 7 months. Projected time frame, it would have already been completed the first part of September. And I just want to kind of go over some of the stuff that he's objecting about. We've also got a copy of his documentation, Mr. Blackburn. So I just want to go over just the rules and regulations, and we've also have consulted with legal counsel on this.
Just a moment. Amy,
Yes.
were you keeping time?
I get as much
you
time.
get, okay,
Yeah.
okay.
Okay, so we want to go over sections that Mr. Blackburn is talking about, and it is,
He only has 3 minutes like anyone else.
no, that's not what I was told.
No, he did not pay for this appeal. I paid for this appeal, my time is not limited.
When I call, Mr. Blackburn, I'm talking.
I am making a.
Just a
I'm
moment.
talking,
Hey,
Mr.
order,
Blackburn.
order, please, gentlemen. Just a moment. Just
Yeah,
a moment.
he's interrupting me in the middle
No,
of speech.
just
I
a-
didn't interrupt him.
Please, just a moment. I do know that it says in here that anyone that wants to appeal, anyone that would like to speak against, you have 3 minutes.
I contacted Mr. Jerry Baker before this meeting and asked
Okay.
him,
And
he told me that I could
Okay,
talk.
just a moment, please. Counsel, could you tell us what we're in the ordinance that says that he has more than 3 minutes?
The time period of 3 minutes is not in the ordinance.
Okay, but it's just in our rules.
Well, yes.
That we've
I mean, so it's up to the chair to grant the, I guess, the property owner as much time as he deems necessary. So that's in your discretion. Most, in a public hearing, a person who may have, a neighbor or something like that, generally speaking, it's been the practice that 3 minutes has been the time period that's been given to any speaker, whether opposed or in favor of an appeal. And that's been the practice of this board.
Right.
Now, it's in your discretion as the chair if you want to grant more time, because this is the property owner.
Mr. Myatt, my position is that I will grant you 3 minutes, and
Okay.
it'll start now.
Okay, I
So
wanna
you've
go over
already
the
spoke to
specific
that, So you'll
laws.
have 3 minutes.
Okay,
Are you-
section
just a moment, please.
118.
Just a moment, and she'll start the
Okay.
timer.
Section 118-99 and section 118-100. These sections pertain to the ZBA's authority over zoning issues, specifically the enforcement of zoning ordinances. They do not extend the ZBA's authorities in matters involving subdivision regulations. Any alleged errors in the application of the subdivision standards shall be directed to the Planning and Zoning Department. Mr. Blackburn talks about Chapter 90 being the major thing. Well, the application of Chapter 90 does pertain to subdivisions within the city, but it does not grant the ZBA authority to adjudicate issues arising underneath it. Chapter 90 outlines the standards and procedures for subdivision development, which should be enforced by the Planning and Zoning Department, not the ZBA. That's strict rules. 90.61, issue of permits. This section prohibits the issue of permits of structures within non-compliant subdivisions, but enforcement of this provision lies within the building and inspection departments, and ultimately the Planning and Zoning Department, not the ZBA, if a subdivision lot does not meet the requirement and standards, the Planning and Zoning Commission must address the issue, not the ZBA. Section 90-217, compliance with sidelines, the regulation of sidelines must comply with subdivision standards in the planning and zoning issues. The appropriate body to grant variances for subdivision standards, such as the side lot requirements, is by the Planning and Zoning Department, not the ZBA. The ZBA's role is limited to variance concerning ordinances and not subdivision plots. Okay, Texas law, this is chapter 212, specifically states under Texas Local Government Code, it clearly outlines the authority to regulate subdivision lies within within the Nacogdoches Planning and Zoning Department, not the ZBA, to have any sort of authority to address the rules or matters related to subdivision regulations. So in conclusion, the ZBA does not have authority to extend any sort of adjudication in subdivision regulations as outlined in Chapter 90. These matters are within the executive jurisdiction of the Planning and Zoning Department. Therefore, any attempt by the ZBA to adjudicate such matters would constitute an overreach of the authority and could result in potential legal consequences. So I just want to say, how much time do I have, Amy? Okay, so I just want to conclude that this body, you weaponize this board against us. I am innocent, we've done nothing wrong, and the board doesn't have authority over the rules and regulations when it comes to subdivision laws. Thank you.
Okay. Mr. Blackburn, since we have had someone speak against, you do have a chance for a rebuttal. And I will. Pardon? Oh, okay. All right. Is there anyone else? Okay. If you'll.
How you doing? My name's Mario Wesley, and I would just like to say that, I mean, last month or the month before, we was already here with the same case, listening to the same issues. If he lost at that point, I'm trying to see why he doesn't have to appeal to a higher court. Why are we just keep going back to the same court, even though, I mean, I guess he waited till after new members was on and then come with the same exact case. So that's just the thing I was just trying to look at, is that this has already been, for one, he tried to appeal with Bartlett when he approved it initially. He was denied. He came to this board already before he was denied, and now we're here again. And it's just something has to stop, or somebody has to put an end to this, that, you know, just because if it's not his opinion that it should be in compliance, it has already went in front of this board and already been voted on, and it's already been in front of the city employees, and everybody has confirmed that this was a legit movement, and everything is good with this subdivision.
Thank you. Is there anyone else that wants to speak in favor or against? Okay. The public hearing portion of this is closed. And Mr. Blackburn, you have a chance for rebuttal, and I would ask to limit that to 3 minutes. If
I don't
that's,
think that's limited. I can rebut it for how long it takes. I'm not part of the public. I'm the
I
appellant.
know, but
I'll make it as short as I
Okay.
can.
All right.
Okay? But I feel bad for these guys back here, the owner of the property and the developer, because I tried to intervene in this thing at the beginning. You know, when I saw that the property wasn't platted properly, I could just tell by looking at it. I didn't know what code it was and all that, and you can tell by looking at these things that there was something wrong with it. And I alerted Steve Bartlett, and he defended the plat based on Chapter 118. I'm not the one that got us, that was a wild goose chase, Chapter 118. The actual code that is over the shape of the lot, the perpendicular, that's Chapter 90. And we've already been through the thing about whether or not you have jurisdiction or not. You do have jurisdiction. You know, you were given the jurisdiction by the city. The city council added on. They didn't stop at the word chapter, this chapter. They added on for any decision that the city planner makes. Doesn't matter if he's making a decision about signs, which is another chapter, subdivisions, doesn't matter. And that was given to you by the city council. So this notion that you don't have the authority is just a red herring. They're blowing smoke, because you have that authority, and if you didn't, we wouldn't be standing here. I can promise you. And I didn't see this back and forth with the TML. They're talking about, oh, we talked to the TML and all this. Let's see that back and forth. You know, the TML is somebody that, you know, they're not the court or anything else. And that's the thing. This hearing is not between me and the developer or the owner of the property. This hearing is about a decision the city planner made, okay? And I don't know if y'all understand how this works, but whatever the decision is, you can't appeal it to the city council or whatever. The only outcome is I can go to court with it's not suing you, I appeal the decision to court. Guess what? The city can appeal your decision to court. I don't know if y'all understand that or not. The city, if they don't like the decision you make, can appeal it to court. The owner of the property and the developer don't have anything to do with this, okay? They are not involved in this discussion that's going on right now. This is an appeal of the city planner's decision. The city council has given you the authority to adjudicate that. Now let's go over the history of this. Yes, I found out about this plat whenever it went up for sale. It was too late to do anything about that plat. So I had to wait by ordinance until someone applied for a building permit. Okay, that's not, you know, I've been made out to be the villain. They're talking about weaponization. Somehow I'm the villain in all this, but I'm the one following the ordinances. The city engineer defended what he did on Chapter 118. So when I filed the appeal, when they filed for their building permit, I did it on Chapter 118. I don't know these ordinances back and forth. I'm not getting paid to know the ordinances back and forth. We lost that appeal, but the 90 days weren't up. So under our ordinances, you can file an appeal anytime within 90 days, okay? The 90 days wasn't up, and after I lost the first appeal, it was then that I talked to some surveyors in town, and it was a local surveyor who told me about the Chapter 90 and how the subdivision rules are. Well, I went home and read Chapter 90, and that's when I realized that the city planner had violated several ordinances. So it was my right, as an aggrieved person, to file the second appeal. There was nothing wrong with filing that second appeal because I was within the 90 days. They're making us all. And what was adjudicated the first time had something to do with lot width at a Chapter 118. This is a totally different appeal that doesn't have anything to do with lot width. Mario was saying, well, this is just the same thing all over again. No, it's not. I'm over the target now. And that's why everybody's setting their hair on fire, okay? Trying to tell you you don't have the authority to adjudicate it, trying to cancel the hearing. This is the root of the case, is the Chapter 90. You do have the authority to adjudicate it. And I think, you know, I'm a physicist, so not only have I, you know, when I look and see that there is a problem, I tried to figure out, well, what's causing this problem? You know, why am I back in here after the Logansport Street fiasco? I'm back in here again, and I'm looking at this administrative plat thing, the Section 90, 122M. I think I'm going to approach the City Council about revoking that. You know, that gives the authority to the city engineer and the city planner to approve these plats, sign off on them, without going to the Planning and Zoning Commission. No hearing or nothing. And they don't publish their work, so I didn't even find out about it until after the 90 days was up. They have demonstrated not only on this one, they didn't require the variance on Bohack's lot, they were supposed to. They didn't require the variance on James Hurst's lot next door, they were supposed to. They have systematically, because why? They have to publish this in the paper, a notice, they have to have a hearing, there's this delay. They have systematically demonstrated that we can't rely on them to follow the ordinances. I think that Section 90, 122M should be revoked. I think all subdivisions where there's just 2 lots, 4 lots, 100 lots, has to go to the Planning and Zoning Commission to be supervised. I feel bad for the guys back there. They say they did nothing wrong. This is not about anything they did. This is about what the city has created this mess. And, you know, and this mess, I feel a little bad for them because this all goes back to the previous city engineer and city planner. They're the ones that signed off on this plat. These guys inherited it. But, you know, they should have required the variance before they approved the building permit. That was their purview. So I don't feel that sorry for them. They didn't follow the rules. Again, and in cases like this, here's another thing that I think should be changed.
Okay, Mr.
Okay,
Blackburn.
I'm
if you'll-
wrapping it up.
I was going to say, just keep it to your appeal, please.
In wrapping this up, I would say that since, in a case like this where you're appealing a ruling, a decision of the city planner, he's a city employee. I think this is different than someone coming in and applying for a variance. Okay, and I never said that you guys could approve variances. It's the Planning and Zoning Commission that does the variance on this lot. But y'all look at doing variances for Chapter 118. Y'all look at doing appeals of the city planner's decision. In a case like this where I'm appealing the city planner's decision, I think you need your own attorney. Because the city attorney has a dog in the fight. He can advise you, but he can also appeal your decision to court. Now, do you think that the city attorney is going to give you unbiased advice when he can appeal your decision to court? I think in these cases, and it is the duty of the city council to provide funding for this body, I think you need your own attorney in cases like this where you're appealing the decision of the city planner, because that's a conflict of interest. I don't think you're going to, nothing against Jerry personally, his job is to protect the city. So he's going to try and make sure that he doesn't have to file the appeal to court, okay? So again, I request that you grant this appeal. This will get things back on track, and it has nothing to do with anything the owner of the property or the developer has done. The misstep was with the city planning department. They should have required a variance that would have opened up a public hearing for all the people in the neighborhood who have been disenfranchised to be able to have their voice in this before the variance was granted or not, and that should have all happened before the building permit.
All right. Thank you, Mr. Blackburn. At this point, does the board have any questions of staff, or?
I have a question, Mr. Baker.
Okay. And if you'll just in the microphone so they can, I think they're streaming this, or I think they're.
That's fine. Mr. Baker, is it your opinion that this board has the jurisdiction to hear this?
It's my opinion that this board does not have the jurisdiction to hear this matter.
Thank you, sir.
Okay. I do have a question. Do you have the city code there?
I do.
Okay. Could you read 118-99?
All of it?
Well, where it says that the Board of Adjustment shall have the power to hear and decide appeals, where it's alleged that there's an error in order, where there is error in any order, requirement, decision, or determination made by the city planner in the enforcement of this chapter and city rules and regulations. Is that verbatim, 118-99-1?
That's correct.
That is it verbatim? Mm-hmm. Okay, then how are you basing your answer that we don't have jurisdiction over this?
Well, by this board's own rules of procedures, which it adopted, it states, the board shall only consider requests authorized under section 211-009 of the Texas.
Excuse me, where are you reading that?
4.1.
In our rules?
Yes.
Okay, 4.1, okay.
The board shall only consider requests authorized under section 211-009 of the Texas Local Government Code as may be amended and under the Texas ordinance, and under the zoning ordinance, as follows. To hear and decide an appeal that alleges error in an order, requirement, decision, or determination made by the administrative official in the enforcement of any order or ordinance pertaining to zoning.
Okay.
That corresponds
now, I know
with.
that when I've been on, I've been on the board several years, we've heard variances for fences, we've heard variances for driveways, and that really didn't have to do with zoning.
They're under the zoning
But
ordinances.
that has to do with the.
Correct.
Okay.
So
And-
that, what I was going to point out is that corresponds with the provision from the local government code, which is cited there, 211-009, which states that the Board of Adjustment may hear and decide an appeal that alleges error in an order, requirement, decision, or determination made by an administrative official in the enforcement of this subchapter or an ordinance adopted under this subchapter.
Okay,
And the
so
subchapter is the zoning.
Okay, but I think the key word here is or, because we can hear and decide an appeal that alleges error in an order, requirement, decision, or determination made in the enforcement of any order or an ordinance pertaining to zoning.
Correct?
So I mean,
An ordinance pertaining to zoning,
I know, but it says or an ordinance.
pertaining
can-
to zoning.
But it says to hear and decide an appeal that alleges error in an order, requirement, decision, or determination made by an administrative official in the enforcement of any order. Okay, that's our first requirement. Or we can make a decision, appeal, or to an ordinance pertaining to zoning.
An order or ordinance pertaining to zoning. I would say the pertaining to zoning applies to the order or the ordinance.
Okay, but it's still, that's not, and this was just signed February of '24, these new rules,
Correct.
correct? Okay, I'm seeing that now, that these were, so what are our city code, does it reflect these new rules?
Do
I mean,
they,
if someone they're looking for the city code, and they're gonna see where their appeal process is, they're not gonna find this, correct?
well, it would be on the website. It's under your,
Okay, but it's not, okay. Where are these exhibits, where it says Exhibit A, Exhibit B, and Exhibit C, under this types of appeals?
can I show you?
Okay. Oh, it's in the back?
Yes.
Okay. Do y'all have any questions, or do we need to? If y'all will give us a minute, we were gonna, see if there's any other questions. And then, do you have anything that you'd like to ask?
No.
Do you, David? Do you have any questions?
I'm just concerned about, like people who are living in the subdivision, from, pretty new, from what I'm hearing is, that for no fault of anyone's, that someone bought a plot and is now building something that, is not congruent with the rest of the subdivision. And the, members who live in the subdivision didn't really have a say in that. Am I interpreting this correctly?
Oh, okay.
And that is part of what I wanted to make sure that, reason why we're here today, right?
No one asked him the question. This is a discussion here, recognizing him.
Okay.
I'm just
I
recommending.
did recognize him to explain this to
I'd
our,
like to hear him speak.
yes,
please.
I was sorry to say, I recognize him to speak to her question.
So the idea behind it is, what we're discussing right now is not what's being built, okay? The duplex that this gentleman over here is building today is not the reason why we're here today. We're here to see if you, as a board, agree with the appeal that has been put forth by Mr. Blackburn, or if you don't agree with the appeal, which means that out of the 2 points that were called out as, which is Chapter 90, 217A, and Chapter 90, 217B, I believe it is, about minimum lot size in the subdivision ordinance, and also about lot lines in the subdivision ordinance. So it's not about the land use. The land use has already been dictated, it's already been set. It's nothing to do with the type of construction that's being done. It is only to say is that if the planner, at the time that they made this decision, did they do it incorrectly or did they do it correctly? And the points, I mean, I don't want to go back and tell you the points that staff was making. Oh, I'm sorry, go ahead.
So basically, they went in and they drew these lines incorrectly, or not according to instruction or protocol, the way land lots should be drawn.
Well, I guess that is the question, right? So the question is that staff is saying that the person at the time, due to the fact that they did draw it, maybe not in the best way, let's just say that, is that I think Mr. Blackburn is right. 100% is that, would it make sense to actually draw it on the angle as he was showing for that neighborhood along Martinsville Road? Because all those lots beside it, when those were platted, which is in 2005, and the ordinance that we're discussing right now is actually approved by city council and by city council and P and Z back in 1970. So technically, those lots really should have a perpendicular line, but it wasn't caught at that particular time. And it does, it makes more sense from a real estate side of things, from everything. It makes more sense to change that line and go diagonal with the rest of the lot lines along that road. That totally makes sense. However, the ordinance doesn't say that. The ordinance states that you must draw a perpendicular line, or have an option otherwise, or note it otherwise. And so because the line was drawn perpendicular, there was no need to have the variance, because in the planner's eyes, they did what was supposed to be done. I mean, again, it's a difference of opinion, but that's what I believe.
Okay. Thank you.
I'm
Did
sorry.
that answer your question, Jacqueline?
It
Okay.
did. But
And-
not,
And I know there were, well, I have.
Okay, thank you. Mr. Blackburn, if you could limit your response to 1 or 2 minutes.
You're absolutely right, Jacqueline. This required a variance from the get-go because the pre-existing lot lines were not perpendicular to the street. It's not just the one lot line. The ordinance calls for lot lines. So there should have been a variance at the very beginning, which would have then had the public hearing for all the neighbors to be involved. That was circumvented and bypassed. That's what this hearing's all about. This was all about the fact that they granted a building permit without the variance. And this required a variance from the get-go, and they didn't require them to get the variance, so the neighborhood was never heard from. This should have been done properly. The neighborhood should be heard from.
All right. Is there, I still am having a question on whether, on our standing or authority or whatever about hearing this. I guess I'm just thinking, I've been on the board and I did not realize we had these rules that were just signed in March of this year. And so, but isn't it, these rules are referencing the Texas government code or?
Texas local government code.
Texas, but yet we have a city code
Correct.
that is saying that we do have this right, correct?
Well, I would read this, our city code in accordance with state law, and state law is under the Texas local government code, and
Okay.
it says zoning. And the zoning subdivision, that's what it talks about when it talks about, and recall, this is the zoning board of adjustment, not the subdivision board of adjustment.
Right.
If
But
the,
it does say that we have the power to decide appeals of the city planner's decisions.
city planner and the enforcement of this chapter and the city rules and regulations, it says that in the city code, correct.
Okay, so I think it's kind of open to, I mean, I think it could be interpreted either way. I mean, because it doesn't specifically say subdivisions, or does it specifically exclude subdivisions?
Well, there's nothing in the subdivision ordinances that gives any authority whatsoever to the ZBA.
Okay.
The only
who is-
body that's mentioned outside of city council is the P and Z.
Okay,
And that's when it comes to variances.
And that's where this needs to be, or is that,
Well, that's assuming there was a variance that was necessary.
okay.
But again, that didn't happen. The plat was approved over a year ago.
Okay. Does anyone have any other discussion? Because right now I need a motion
so
either.
because the plat was approved a year ago, and no appeal was done then, is that why you're saying that this board doesn't have?
Right.
I'm saying that this board is not authorized under the state law or our city ordinances to address subdivision issues. If there are rights of appeal under the subdivision code, under both our city code and the state law, and particularly under state law, you can appeal a matter to city council and up to a judicial court if you're dissatisfied. But that's generally limited to the applicant who is denied his subdivision. Recall that the applicant here was Mr. Johnson. He's not a party here anymore because he sold both lots to individuals who just happen to be here. You've heard from both of them.
have a question, Mr. Baker, again. What are our options as far as a motion?
You can approve the appeal or deny the appeal.
Okay.
Yeah, that's all,
That's
that's
it.
our only option,
Okay.
is either, because that's what's been brought before us.
Okay.
We either we're considering the request for an appeal to the city planner's decision. So at this point, I either need a motion to grant the appeal, which is to, it's the appeal as it applies to the approval of a building permit and site plan, or I need a motion to deny the appeal. So I would entertain that at this time, and then if we have a second, then we can discuss it among ourselves. But as of right now, we can't discuss it among
Okay,
ourselves.
Can I ask one more question of Mr. Baker? It almost, to me, that if we vote to approve or deny the appeal, that we are saying we have jurisdiction. So if we feel like we don't have jurisdiction, is that still our only two options?
Well, you can deny the appeal because you don't have jurisdiction.
Okay. Make a motion, we deny the appeal due to lack of jurisdiction.
Do I have a second?
I'll second.
Okay. We're now in discussion.
Okay. I have feelings, okay, but, I just feel like the people who live in that subdivision,
We're really not, that's really not what we're,
okay, and I get
yeah,
it.
I mean,
Okay.
I understand where you're coming from, but that's not really what the debate is about right now.
Okay.
It's about whether the city planner was not, the city planner granted a building permit when it should not have been granted,
Okay.
is where we're at now. So, do you have anything you? Discussion.
Just a question more than anything. Is there an appeal now to P and Z, or is this matter over, or what's the next step?
Assuming the appeal is denied,
All right.
then the applicant has the ability to appeal it to either the district or the county court of law under both state law and our city ordinance.
Okay.
But if we don't have jurisdiction, does that,
Well, again, if the motion that's on the table is a motion to deny based on lack of jurisdiction, as I understand, correct? Okay.
What happens if we don't deny it?
well, right now, we've got a motion on the table right now
Right.
to deny, and we would have to take a vote on that.
Correct.
And then if you were wanting to approve it, then that would be another
You know,
motion.
depending on the vote on that
Yes.
motion will
Would determine.
determine whether or not you have another motion. And depending, you need 4 votes to approve
Yes,
any appeal.
Unanimous.
yeah, it has to be unanimous.
Okay.
Is there any other discussion?
No.
Okay.
And the reason why I ask that is, if they're saying we don't have jurisdiction and we vote not to deny the appeal, and we didn't have jurisdiction, what would actually happen?
According to what Mr. Baker said, they could appeal to a district court.
Okay, so whether we appeal, so however we vote, it's gonna go up.
So your motion is to deny the appeal based on the fact that we don't have jurisdiction?
Correct.
Okay. I'm kind of reading this now a little differently than what I had, when I read the code. I know in other boards that I'm a part of, or your code is your first line of defense, correct? And then
Correct.
a rule is just, I hate to say, a suggestion. Your rules are the suggestion of how you're gonna follow the code.
Well, you adopted it, so it applies
Right.
to you.
Okay.
So
But
if
I
you.
guess what I'm asking is, where is the Texas local, where is section 211.009 of the Texas Local Government Code? It's not in our city code.
No, it's state law.
So you would have to go to that code, 211.009, to find what we're really authorized to hear.
And that's what I just cited to you earlier.
Okay.
That's- I
I
can
will
reread
say,
it
I think
if you-
that's a little cumbersome for people.
Okay.
If they're wanting to appeal, this really doesn't, the code doesn't matter then, correct?
I wouldn't say it doesn't matter, no.
Well, yes, because you're saying that it has to fall under this Texas Local Government Code.
Well, I'm just reading the rules of procedure that this board adopted, and that cites 211.009
Okay,
of the local government code, as well as under the zoning ordinance, which is chapter 118 of our code.
Usually like when you.
which is
oh,
118,
Yes,
which is 118, just say appeal of city planner's decision. 118,
that's included,
100A.
yes, correct,
And it says appeals to the Board of Adjustment may be taken by any person aggrieved,
correct.
or by any officer, department, or board of the city affected by any decision of the city planner.
That's correct.
Okay, so how are you saying we don't have jurisdiction?
Because the basis of the appeal is under subdivision ordinances rather than the zoning ordinances.
Okay. I think that we need a lot of clarification in our zoning.
I don't disagree.
Okay. We still have a motion and a second, and we're still discussing about, the motion is to deny the appeal based on the fact that we don't have jurisdiction. So is there any other, more discussion? Then we'll call for a vote. All in favor to deny the appeal based on the fact that we don't have jurisdiction, all in favor, say aye.
Aye.
Well,
Lord.
I do have one other.
Well, we're in the middle of a
Okay.
vote. I'm gonna have to be a no. I read this 118, 100, that I think it needs to be a lot more clear. So, we didn't have a majority, so we're now,
Need a new motion.
now we need a new motion. It was a yes.
Mine was, when you have like an instruction or a code.
Oh, she wanted to know, it was yes, yes, no, and yes.
But I'm kind of on the fence still.
Okay. Oh, okay. I thought we had to be unanimous to approve, has to be unanimous.
Can I change my,
Pardon? That's what I was,
Approve an appeal has to require 4 votes.
okay. To deny is a simple majority.
I have a question before.
Okay,
That-
just a moment. The motion, Yes.
I said,
Just-
I'll be happy to answer
Okay.
the question after the media. That doesn't matter to me.
okay.
yeah. The motion carries. The motion to deny the appeal based on jurisdiction, that we do not have jurisdiction, was a vote of 3-1. I now would ask if there is anything else. There was nothing else on the agenda, correct? That's correct. Okay. Then our meeting is adjourned, and it is 5:44 p.m.